Okay, I'm going to start by asking each of you a question, and then we'll sort of open it all up. Josh, let me start with you. Okay, this is a new book called Debating the Death Penalty. It has a bunch of different essays in it, and Josh has one. And I'm just going to read an excerpt and ask you to elaborate. Okay. New urban myths have been created by those who zealously seek the abolition of capital punishment. After having largely lost the argument with most Americans, and also with most Europeans for that matter, the death penalty is morally wrong in any case. Have lost the argument that it's morally wrong in any case. Sorry to be distorting what you said. Opponents have tacked into the wind and come up with a new troika of arguments. 1, innocents crowd America's death rows. 2, the death penalty is irretrievably racist. And 3, defendants facing capital punishment are offered poor legal representation against massive government resources. Now, Josh, can you elaborate on any one of those sort of three myths that you think dominate the debate unduly?
Well, I don't doubt that there is a little truth in all of them. For example, I think anybody who supports the death penalty would have to concede that there have been innocent people put on death row. No question about it. There's considerable debate on how many. And even Jed Rakoff, who here in New York City declared it unconstitutional back in 2001, put that number at about 30. I think Amnesty International puts that at, and I think Barry's organization at about 130, 125, 130. And so you can make certainly the argument that 1 is unacceptable. The issue, though, is if you ask the American public, and there have been polls as recently as last year, and it's a terrible question. The way the poll is asked is, do you think murderers should get the death penalty? If you were to ask me that question, the answer would be usually not. But so we had, for example, in the millennial decade, 590 executions in America, 26% more than in the 1990s. So the subject of tonight's is the death penalty dying. Now, I don't expect this group, to applaud like the Tea Party people did to Rick Perry when he talked about how many people Texas had executed. But that's a significant rise. Now, the next number is one I hope that everybody would really get excited about, and that is in the same 10-year period, murders in the United States went down 22%. Now, one can certainly make an argument that, well, that has nothing to do with the death penalty. Or you could subscribe perhaps to what Cass Sunstein, who's now a member of the Obama cabinet, who in 2005 wrote a very compelling paper called Is Capital Punishment Morally Required? A Life-for-Life Trade-Off? And his point is that if, in fact, a series of studies by non-ideological academics, starting in about 2000, show that for every execution, 17 plus or minus 7 innocent people are not executed, are not murdered. If that is true, and even if it's at the low end, 10, and if you don't execute, say, 500 people, and you know that as a result of that, 5,000 innocent victims will die, Sunstein's thesis is, how can you not have it for the worst of the worst? Most people, just for fun, if this audience tonight, could you raise your hand if you're opposed to the death penalty generally? Okay, it's a little hard to see, but I guess about 75%.
It probably seems about right. Yeah.
And if your belief is because of moral or philosophical, if you believe the death penalty is wrong, and that simply, flat out, the state just should never take a life, or the classic conservative view, which is we can't trust the government to do most things, we sure as hell can't trust them to kill anybody, then there's nothing tonight that I can say that is going to dissuade you otherwise. To answer your question directly, though, what has happened in popular culture, and I saw Barry on a movie called Conviction, I think playing himself, and then on a hit TV show.
That was Peter Gallagher.
I'm sorry, Peter Gallagher. That was actually...
I'm not sure Peter Gallagher would have been too happy to hear that, but anyway.
But Barry did play himself in a TV show called The Good Wife, which had a thing about the death penalty. And what I am concerned about is that people's decisions are getting to be made on the theory that a significant number of people, polls show that as many as 20 to 30% of Americans believe that over 25% of the people on death row are factually innocent.
Okay,
now, I'd be very interested as someone, and by the way, I was a defense
okay, let me just jump in and ask Barry a question that sort of comes off of that. You and the Innocence Project are very much associated with the exoneration of people who are factually innocent. And, you know, we are all, I suspect, very familiar with the extraordinary work you've done in that area. Is the reason you oppose the death penalty because of these mistakes? Would you oppose the death penalty if the factual guilt were beyond question? Or is it the risk of mistake the reason that you opposed?
Actually, there's a great Stephen Colbert where he asked me that question, but he has it differently. He was talking.
He says it funnier than I do, right? I mean, that's...
No, I think that the argument with respect to capital punishment is a public policy argument. I think that there is an unacceptably high risk of executing innocent people. It is not just the post-conviction DNA exonerations of people that were on death row. It is not just the exonerations off death row of people with new evidence of innocence. People can quarrel about how big those numbers are. It is not just, let's say, the execution of Troy Davis, that I hope we can talk about in greater detail, yes, where I think there are very grave and substantial doubts that it looks like the state of Georgia executed an innocent man. As readers of The New Yorker, you're all familiar with the Cameron Todd Willingham case, and there's even more information about that. And I would put that into the category of the safety valve. It's said that there is a safety valve, which is boards of pardon and parole, like in Georgia, or the governor being able to execute, prevent executions in cases where there's some residual doubt, to use a term. Let me tell you about a case. How many people here have heard about the case of Claude Jones in Texas? Well, I see
not many.
No one. All right. Now let me, Josh, do you know about that case?
I've heard of it, but I'm sure I don't know the details.
Let me just, no. Let me just, I just want to demonstrate this, and now you tell me if you don't think this is significant. On December 7th, we're just talking here about the unacceptable risk of executing the innocent. My big argument, I don't want to hog time here, but my big argument is that as a public policy matter, the death penalty is too expensive. There is no persuasive evidence that it deters. We can increase public safety by taking the money that we spend on capital punishment and put into other things that we know enhance the capability of law enforcement, not just to protect the innocent, but apprehend the real perpetrators. And we'll discuss that more. But let me just share this with you. On December 7th, 2000, George Bush executed a man named Claude Jones. It's the last person he executed. At issue in that case, Claude Jones was convicted of this murder, long story short, in Texas, where, based on an accomplice's testimony, in order to sustain that conviction, there was microscopic examination of a hair that was found on a countertop where a gay store owner was shot by somebody. Jones said, it wasn't me, it was a guy named Dixon. There was only an accomplice saying that it was Jones. 3-2 decision of the Texas Court of Criminal Appeals. As Danalynn will tell you, they're not flaming liberals, the Texas Court of Criminal Appeals. Josh will tell you that too. Said the only reason we're sustaining this conviction is that there is this hair evidence that is the independent evidence that's necessary in Texas to corroborate the accomplice testimony. We then, many years later, about 5 months later, with the help of Mark White, former governor of Texas, who executed 22 people himself, and with publications, we were finally able to get this hair that was preserved, which was said to be consistent with Jones, not from Dixon, not from the victim, and not from another 12 people that might have been in the store. We got DNA testing of the hair. The hair is not from Jones.
When did you do all this testing?
This happened 5 months ago.
Well, even after his been...
Yeah, I'm talking about 5 months ago. He was executed in 2000, wow. Okay? It showed that the hair was not from Jones, all right? So it can't be independent corroborating evidence. It was from the victim. It was not from Dixon. It was not from the other 12 people. And this was the biggest thing that the prosecutor relied on, and the thing that the court used to sustain his conviction. So what that means is he was wrongfully executed because there was legally insufficient evidence. Doesn't mean he's innocent. Here's the troubling part. Here's the thing that is mind-blowing. This happened, by the way, just as Bush was coming out with his book, right? And I actually had to call him and tell him, look, I didn't plan it this way. I swear to you, I didn't plan it this way. In the memos that went to the governor, not by Gonzales, he was gone by then, in the memos that went to the governor saying to him on December 7, 2000, you should approve this execution, they say there's evidence of guilt here. It's the hair. The hair is the corroborative evidence, and none of them told them that the defense lawyer had made an application to have a mitochondrial DNA test done on the hair. He wasn't even told. And I believe, based on the fact that he did give us stays to do DNA testing before execution in 2000, personally, right, that his brother granted such stays when he was governor of Florida, there's no doubt in my mind that if he had been told that they wanted to do a DNA test, he would have postponed the execution 30 days. There would have been these test results, and this guy's conviction certainly would have been vacated, but there's no question in my mind that he wouldn't have been executed. So how do you say that that system isn't 100% broken?
Okay. Danalynn, let me ask you, let me just offer a brief preface to this question. I think as most people in an audience like this know, in death penalty cases, the Supreme Court requires two parts to the trial. First, there's a guilt phase. They determine whether the person is guilty of first-degree murder. And then there's the penalty phase, where the jury has to decide whether the death penalty is appropriate. And the prosecution gives evidence tending to show aggravating factors in the term, and the defense shows mitigating factors. And then the jury reaches a result. Danalynn, you have focused a lot on the penalty phase of death penalty cases, and particularly in the mitigation process, the evidence that can be presented to a jury in mitigation. What works? What's useful, what is good evidence in the mitigation process for a defense lawyer?
Well, what's good evidence is evidence of the life history of the client. And in some ways, it's whatever that life history might be. Their complexity as a human being, obviously there are mitigating factors, the more classic sense of mitigation, which is mental illness. Mental retardation is actually an exclusion now, not a mitigating factor. There's life history of struggles that people have overcome or that have overwhelmed them. Poverty, drugs and alcohol, and other hardships. Sexual abuse is very common in these cases. There are a lot of cases of folks who are suffering from trauma from child abuse. Those are what people think of as the classic mitigation. But that's actually not the only thing that works, and those things standing alone don't work. What works is for jurors to get to know the defendant. What works is for them to understand that this is a human being, and for their story to be told in all of its complexity. And so to contextualize the times that they've failed and where their flaws have overwhelmed them, and then also to highlight the times where they've been successful and they've overcome other struggles. And to tell that story in a humanizing way, to bring in people who actually know them. And I think that what happens in a mitigation, a penalty phase, where this is a death-qualified jury, nobody gets on the jury unless they're in favor of the death penalty, so it's not that these folks went in knowing that they were going to decide this. They went in thinking they would probably want to kill him. So you have a death-qualified jury, and then you have them having already made a unified decision to convict someone of capital murder, the worst crime in our law, and then yet decide that his life is worth salvaging, and decide to choose life. And it happens from getting to know them. And I think that that's what we're seeing with the death penalty sort of in general, is that once people get to an opportunity to examine what really happens and who's really getting the death penalty and who is actually being executed and not being executed, that they have second thoughts about it. And, when you ask people in general, are you in favor of the death penalty as a public policy, a lot of people sort of a knee-jerk reaction say yes. But when you ask them if life is a possibility, then it goes down a little bit. But when the people actually get involved and learn about the cases and learn about the defendants, then those people who think they're in favor of it change their minds. And that's really what mitigation is.
Mark, Richard Allen Davis was convicted of murdering Polly, your daughter, and he was sentenced to death, and he remains on California's death row. California has technically has a death penalty, but there are like 600 people on death row, and years go by without any executions. I don't know if that counts as an actual death row or not. You, in addition to being a member of a crime victim's family, are very active with crime victims. Does the death penalty help? Does having Richard Allen Davis sentenced to death and potentially executed help?
First, to correct something that you said, there are actually about 750 individuals on death row in California, in a state that's executed 13 of those heinous criminals over the course of the last 30 years. So I think we will certainly agree that the death penalty is a broken system in the state of California. But to your question, in a roundabout way of getting there, exactly 18 years ago today, on the 1st of October, 1993, my 12-year-old daughter, Polly, was having a slumber party with two of her girlfriends in the home that she shared with her mom in Petaluma, California. And at about 10:30 at night, as the girls were getting ready to go to bed, the room was invaded by a knife-wielding, bearded stranger who told them that if they made a sound, he would slit their throats. That effectively halted the screams that were ready to emanate from them, and he proceeded to tie up Polly's girlfriends. He gagged them, he bound them, and he stole my daughter into the night. We spent the next 65 days searching for her, only to find that this recidivist violent offender, who had only recently been released from prison for having pistol whipped and kidnapped his second kidnapping victim, had decided that he would avoid AIDS. And this came out in the court testimony. He decided that he would avoid AIDS, which was a real problem at the time, by getting a young one. So he proceeded to get to know my daughter in ways that a jury would never be able to get to know him. And he proceeded to rape her and to squeeze the life out of her. And I'm no doubt that the last thing my daughter saw were the dead eyes of her killer. Now, it occurs to me that the kidnap, rape, and murder of my daughter Polly was this particular individual's definition of safe sex. Now, I believe that it's required in a situation like this that the individual, and there's no consideration, no doubt about the guilt in this case. Everybody knows that Richard Allen Davis murdered my daughter. That he deserves the worst possible penalty. He deserves whatever penalty the state deems fit to give to him. And in this particular case, that's the death penalty. So does it help that he's on death row? If he had received anything less, it would have diminished my daughter. It would have diminished the criminal justice system, and it would have given a big win to him. Because the one thing I notice on all of these guys is the one thing that they want, the only thing that any of these guys really want at the end of the day is to live. So they can kill with impunity. There's no problem with that. But when it comes to their own life, they shrink in and will do anything to fight for that life. And in California, we give them plenty of opportunity to do that because, as you mentioned, there have been so few of them executed over the course of the last several decades.
Danalynn, I know something you've done in your practice is you have reached out to victims, crime victims' families, people who've been murdered. Sometimes guilt is not an issue. What do you say to Mark or someone like Mark who feels the way he does?
That I cannot understand, have not experienced the anger and the rage and the sadness that must happen when there's a tragedy like that. And I'm not going to presume to say, oh, I understand that, let me tell you what you should do. But I also understand that what each victim's family needs to heal is different, and that the victims movement has a lot of different voices, and there are victims groups, Murder Victims Family for Reconciliation, Murder Victims for Human Rights, who oppose the death penalty. There are also many victims, individual families, who have been through this process of seeking the death penalty and being told, because it's the only thing that we offer them, that somehow this is going to help, and they spend years pursuing it. And then when it happens, it doesn't help. And in fact, what's happened is they've delayed their grief, they've delayed their healing, and they learn that for them, at least, the revenge wasn't healing. I'm not going to tell anyone that it's not healing for them, but I know that in many instances, when people have thought that that was what they needed and thought that it would help them, they later learned that it didn't, that it was sort of a false promise. And what I would say is that I think that the urge to the death penalty comes from stories like this that are absolutely heartbreaking. And if that happened to someone I love, I'm sure that I would want to personally take them out. And anyone would feel that way, and that's a natural sort of feeling. Unfortunately, there is nothing that we can do to fix this problem, to fix the fact that Polly's gone, that she's irreplaceable, that she's unique and cannot be replaced. And that is a fact that will never change no matter what we do. And our effort to want to fix it, our effort to want to respond in some way has resulted in a public policy that's failed, that doesn't do what it's supposed to do, that's costly, and that isn't a deterrent, and that it isn't really giving the victims the healing, many victims the healing that they need, and many of them say that. I recently represented a man by the name of Race Bouillon, who was shot in Dallas by Mark Stroman, who was executed, was set to be executed this last September. And he was, Race Bouillon had been shot in the face with him, and he wanted to have victim offender mediation, which is something that many prisons offer now, where victims and offenders sit down and talk. And sometimes the victims want to go just to yell at them, just to tell them what they did, the effect that they had on their lives. Other times they're very curious. They want to know things. They talk about having an organic relationship with the perpetrator, where now learning about this person and getting answers from them has become something that really drives them. There's a woman named Paula Curlin who's very much in favor of the death penalty, but advocates and worked with us on that case for victim offender mediation. And all we were asking was for Mark Stroman's execution to be stayed long enough for my client, who was the victim, obviously a surviving victim of him, to have that victim offender mediation. We weren't asking for any remedy that would prevent his ultimate execution, or certainly that would have anything to do with his conviction or sentence being changed or overturned, but for Race to get what he needed to heal. Because again, what people need is different from person to person. And not only did Texas deny him that, and he had the family members of the deceased, one of the deceased victim were with us as well in court to testify. They weren't permitted to testify, but at the press conferences with us in the group. And they wanted for Race to get what he needed. And they had sort of moved on. They said, you know, whether they kill him or not doesn't matter to me. I've learned that my ability to heal, my ability to move forward, my life will never be the same, but to go forward with my life is not dependent on that execution.
Let's talk about...
Can I?
Sure, Mark.
I mean, she was talking about the victims and being the only person here who has any experience with this. I can tell you that the percentage of the victims community, first of all, that's involved in Victims for Reconciliation or victim offender mediation is really pretty minuscule. It's a very small segment of that population, and I don't think it deserves any more weight than it is in representation. So what I would like to say is that I am no longer grieving. My grief is not delayed because Richard Allen Davis remains on death row. My healing process will never end. You don't really get over something like this. What you do is you learn to deal with something like this. I don't put a lot of energy into the fact that Richard Allen Davis is on death row, quite frankly. And I understand that this is a system that's broken, but I would also counter that in many respects the system is broken by the very people that say we need to end the system because the system is broken. In other words...
And who is that?
Well, that would be the abolitionists, wouldn't it? That would be the abolitionists. In California, it's very clear to me that there is a silent protest against the death penalty by the defense bar. It's very simple. We have 217,000 qualified practicing lawyers in the state of California. Well, I've actually read anywhere between 170,000 and 217,000, but be that as it may, there's less than 100 lawyers that are supposedly qualified to work on death penalty appeals. Well, it seems to me that in these difficult times, it would not be hard to find several hundred more of these characters, several hundred more attorneys that would be willing to deal with that particular issue.
Well, let me start. Let's talk a little bit about how, Josh, you mentioned some of this. I mean, as I understand the statistics, in the early 90s, there were approximately 300 death sentences and 100 executions per year.
No, there were. I'm looking at the numbers from 90. Clearly, they spiked probably in 1999 with 98. No, that was the highest.
That's right. I'm sorry, the late 90s. Late 90s, 100 executions and 300 death sentences. Last year, there were 46 executions.
That sounds right. And the year before that, 52. Right.
So you know, and as I understand it, the number of death sentences has gone down similarly.
The number of death sentences, the number of actual executions.
The executions and the death sentences have gone down. That's my general point. I mean, we can argue about the statistics, but the number of executions and the number of death sentences has gone down. You say that is due to the number of murders being down.
Well, I think
crime is down.
It's one of the.
So let's talk about it. Why? Why are death sentences and executions down?
Prosecutors are the gatekeepers of the criminal justice system, and one of the sometimes attacks, sometimes challenges made to prosecutors are that in depending on the size, in a large office, like when the death penalty I think existed here in New York State, which it no longer does, a large office would have a committee of prosecutors that would decide. In a smaller office such as mine, which is actually medium-sized by American standards, I make that decision. To give you an idea, I've probably had to make the decision about 20 times whether or not to actively seek the death penalty. I have stood before juries.
Just to explain, I mean, there are only certain crimes that are even eligible constitutionally for the death penalty.
Right. We had, I mean, in the 2000s, we had 162,000 murders, and we had 590 executions.
Right.
So we're executing something on the order of 1/10 of 1% or maybe 1/50th of 1% of murders. And appropriately so. Most murders don't deserve the death penalty. As you say, for aggravated or special circumstance murder, it requires the murder of a police officer, the murder of a child, serial killings, things like that. So, and there are a lot of factors that go into that. One of them is, what are the desires of the victim's family? And Danalynn is right. I mean, I have had situations where all other things being equal, I might have sought the death penalty, but the victim's family was very much against it and said, not in our name. It would do, they thought it would do violence to their, and I had to respect that as a factor. Of the 20 cases, for example, approximately, in which I could have sought the death penalty, in only 2 have I stood in front of juries and said, and I don't try to underwrite the responsibility I'm taking. I am standing before a jury saying that person should die. And there's no getting around that. I've done it twice. One defendant actually has been given the death sentence 4 separate times, and there's the issue.
This is the Marc Guzik,
the Randy Guzik case. It's been before the U.S. Supreme Court.
Right, and it was a home invasion where they killed 2 people.
It was a home invasion, but with the intention of murdering. It was not a burglary gone bad. But there's never been any issue about prosecutorial misconduct, police misconduct, DNA evidence, actual innocence, none of that. In fact, the issue was whether or not the victims had any right whatsoever, any right to be heard.
Okay,
because until 1985, that didn't happen. My point, Jeff,
why are death sentences and executions down?
They're down for a number. They're down because murders are down, which is everybody agrees is a good thing. They're down because I think prosecutors are becoming much more discriminating in when they seek the death penalty. I think jurors are being more discriminating. I did not nearly as much as what Deanne has done, but when I was a defense attorney, I convinced both of my capital eligible clients, I put together a 100-page mitigation. I did what Benetton, you may remember, tried to do about 10 years ago. In Vanity Fair, they put together this thing called We on Death Row. And they tried to take about 20 people who are on death row and humanize them, make them into people. They are people. They're not Frankenstein. They're not Dracula. They have mothers. This was, by the way, one of the worst public relations disasters in history because it took the men from Oregon, one was a serial killer of women, and two had murdered a number of children, and nowhere in any of this does it ever say what crime they committed. And that's the frustration for those of us, because when I tried the Guzik case last summer, there were 115 photographs of Randy Guzik, age 1 through 20. I am permitted under Oregon law exactly one photograph of the victim alive. And I'm very, very constricted. Our cases, and maybe properly so, are about the defendant's culpability in the guilt phase, and then should mercy, the defense made a big deal in jury selection of asking, is mercy bestowed or is it earned? And the judge gave the instruction, which is not required but happens, you may base your decision on mercy alone. And my argument was mercy is bestowed when it's earned. And this particular defendant has never done anything to earn it. But just very briefly, for example, demonizing Texas. I've never voted for a Republican for national office in my life. Certainly not George Bush. Okay,
but you're just playing to a New Yorker audience.
Well, 80% of them already disagree with me. So, George Bush and most Southern governors, Barry will, I'm sure, correct me, don't have the power of plenary commutation, like the governors of Illinois, Oregon, other places do. There's a lot of interesting reasons having to do with the Civil War. All the governor of Texas can do is grant a single 30-day reprieve. For example, and when Ricky McGinn was on the cover of Newsweek in June of 2000, he was Barry's client, I believe, Barry convinced George Bush that there was enough evidence, there was enough question about whether a little tiny bit of something on Stephanie Flannery, who was the 12-year-old stepdaughter who had been axed to death, that might not be Ricky McGinn's DNA. And if it wasn't, then he wasn't a rapist. If he wasn't a rapist, then he wouldn't have been the death penalty. That was on the front page of Newsweek. Good luck. I invite any of your readers to try to Google Ricky McGinn. You'll be very hard-pressed to find out what happened, because what happened was the DNA tests established beyond all doubt that he was not just a murderer, but a rapist. Before that, the great innocent man on death row was a man named Roger Coleman. He was on the cover of Time magazine in 1992. 14 years after his execution, a neutral lab in Canada did DNA testing. And it then established that he had, in fact, raped and murdered Wanda McCoy.
Barry, what's your view? Why are death sentences and why are executions down?
Well, just so we're all clear, I was referring to Ricky McGinn, who was, in fact, guilty. We were called in at the last minute, and it wasn't just a little bit. It was a lot of semen. And, the point was, it was a rape murder. You do DNA testing on the semen. You see whether he's guilty or he's innocent. And that's why I'm telling you that if George Bush had been told about the mitochondrial DNA testing, which the lawyer had asked for on the hair in the Claude Jones case, he would have granted that application. But his lawyers never even told him that that was going on. So that shows you, and he would have granted a 30-day stay. They would have done the test. This man would be alive today. Maybe they could have retried him, but, who knows? So why are death sentences down? Because of cases like Jones, because of cases like Cameron Todd Willingham, because of the post-conviction.
When you say because of what? I mean, are jurors, you think jurors are not?
Jurors, everybody gets all the statistics wrong. There have only been 17 post-conviction DNA exonerations of people off death row, but there have been 275 post-conviction DNA exonerations of inmates generally, many of them for murders, okay? But what people recognize, and I'm sure Josh will agree, that less than 5% of serious felony cases have any biology in them where you can do a DNA test that would demonstrate somebody is guilty or innocent. So what one logically has been asking in the 20 years that we've had the Innocence Project, what about all the other cases where there might have been eyewitness misidentification, which in 75% of our cases is going on, false confessions, bad forensic science, all these other causes of bad lawyers that are not up to the job, prosecutorial police misconduct. These are all the causes of wrongful conviction. So I think that there is a greater appreciation of that, and as a consequence, jurors are a bit more skeptical. Prosecutors, as Josh says, might be a little bit more selective about which cases they take to the juries for that very reason. Mitigation is better. All those things are true. And I think generally the death penalty is no longer, in terms of public attitudes, the third rail of American politics. And if I can address the point where Mark and I think agree a lot about the state of California as an example of my argument here, that, again, reasonable people can differ as to whether the capital punishment is the appropriate sanction for the most heinous of crimes. But what I don't think we can disagree upon in the state of California, it costs, by the latest study that came out in the Los Angeles Times by independent experts, an extra $187 million per year to keep somebody on death row as opposed to general population in the state of California. Because there are...
Wait a second, 187 million or
yes,
187,000?
$187 million
for one
extra a year.
For all of them?
To keep the people on
all of them.
row,
Okay,
for all the
right.
people over the over 700 people on death
row.
row.
I thought you said for each one.
There are more people being brought onto death row in California, and it's going to cost another $400 million to build an extension of death row. These are, I don't think, disputed numbers in terms of extra cost, and that is not dealing with the additional costs of extra time for penalty phase, extra money that goes to the prosecutors, the defense. There have been quite a number of studies, not just in California but everywhere else. This is more expensive. Okay, so the bottom line in the state of California, and it's the place to watch, is that we were just able to get an initiative on the ballot that is saying that when you look at this with these costs per year, if you have mandatory life without parole, and some of the savings that California would get, some tens of millions, would go towards specifically designated towards law enforcement for public safety. Eyewitness identification reform, videotaping interrogations, improvement of crime labs, any of a number of things that will protect the innocent and help apprehend the guilty. The question is a public policy one as to whether that's worth it. The state of New Jersey had a commission that reviewed all of this. The legislature repealed it. In Connecticut, I think the votes are there next year. I think it will be repealed. It was recently repealed in New Mexico. In Maryland, I think that there's an anti-death penalty Governor O'Malley, anti-death penalty governor recently elected. In Connecticut, obviously Jerry Brown, the Attorney General Kamala Harris, Gavin Newsom, the Lieutenant Governor, they're all opposed to capital punishment. Andrew Cuomo, famously opposed to capital punishment in the state of New York. It is no longer the third rail, and in general, I think the public now sees it like Europe. Right. The book to read is The Contradictions of American Capital Punishment by Frank Zimring, where he does a public opinion poll in Europe. And 65% of people in Western Europe now, if you ask them, are you for or against the death penalty, they say, I'm for it. However, why don't they want the death penalty brought back? Because, as I think Josh said it before, and what George Willis said, capital punishment, like criminal justice system, is just another government program. They don't trust the state to get it right. And when you look at the United States, as Zimring lays out in the book, the 12 states that execute the most people are the 12 states that historically had done the most lynchings. And it's not just a question of race. What Zimring says, it's really just a question of, in some ways, vigilante justice mentality.
Okay, let me just... Danalynn, let me ask you something that respond to what Mark said, and then Mark can respond about this. He talked about the length of time. Mm-hmm. Troy Davis, the crime was 1989. His trial was 1991. He was executed last week. That's unusually long, even by contemporary death penalty standards, but 10 years is certainly not long. Is that a sign of the success of the system that it takes so long, or is it a sign of a failure of the system?
Well, I think it's an attempt to make a failing system work, and it's a failed attempt to do that. The reason that the cases take so long is not just that there aren't enough lawyers doing the work. It is that the process requires, because with human lives at stake, that we look at things carefully, that we re-examine and reinvestigate, and the bottleneck is often the courts as much as anything. Many federal judges, when the federal habeas appeals got sped up in the AEDPA, it was federal judges who complained the most because they already understood that their dockets were so clogged that they couldn't go any faster. And the court system, regardless of how many lawyers you have, there's only so many jurisdictions, there's only so fast and so many courts and so much personnel, and there are so many cases. But it's also a function of the fact that what happens at trial is that prosecutors will argue to the judge that we need to hurry up and get this case to trial, and there is a rush to justice immediately. There is a sense of wanting to respond immediately. Funding for things like experts and investigation is getting better, but it is still limited and crippling many efforts in these cases. So on the front end, the prosecutors are saying to the judge, look, there's a long process of checks and balances. If we get it wrong, we need to be in a hurry. And then those same prosecutors will say, when you get to direct appeal, a judge has spoken, everything was looked at very carefully, we had these pretrial hearings, and then they'll say when we get to post-conviction, there shouldn't be funding, there shouldn't be additional testing because he got a fair trial and a jury has spoken. So at whatever stage you're in, it's like this. They're pointing to the other stage. That's when something should have happened.
Mark,
and there's a lot of waste and inefficiency as a result.
What's your reaction to the issue of how long it takes?
Well, let me just, speaking from my own personal experience, and the idea that there's this rush to judgment to get these guys into trial and to get them on to death row, I can tell you that in our case it took 3 years to come to trial. I can tell you that in our case they requested a change of venue, which was granted, and that the state of California picked up the cost for 2 death penalty qualified attorneys to defend Richard Allen Davis. And I can tell you that they brought in as many experts as they wanted, and that some of the money that was used, and they were very well funded on the other side, some of the money that was used to bring his family into trial so that they could sit in the trial. But I can assure you that the victim's family, my family, had to move to the new venue, and we had to do that at our own expense. I was taken away from my wife for about 5 months, simply because I wanted to attend every day and I needed to attend every day, but I had to pay for the ability to attend every day. So the idea that of this disparity of funding, that the defendant is not given a fair shake, I think is, at least in the state of California, and I'm sure Josh will tell you the same thing, is an absolute absurdity. And I think we need to set the record straight on this. The money exists for these people to be able to defend their lives in the state of California, and it's used very generously.
Josh, let me ask something about, you write in your book, or in your part of the book, the subject of the death penalty in the United States historically has been very bound up with the subject of race. And you write, really very candidly and interestingly, I mean, your county is almost all white, but you had to decide about whether to bring a death penalty case against an African American who was, the suspect in the case. I'd like you to talk about the issue of how you dealt with that issue, and also everyone more broadly of the question of race and the death penalty, and we can get more specific, but why don't you just start by talking about that?
Well, the county that I'm in now, I've been the elected DA for 18 years. That was another county in Oregon about 200 miles away that's even less ethnically diverse than the one I'm in now. Oregon does not have a large, I think the overall percentage of African Americans is about 3%. To live in America and not recognize that racism isn't a factor and hasn't been bleeding into the justice system for hundreds of years would just be to be in denial. I think we've made enormous progress. The lead district attorneys in many of the major jurisdictions in this country are African American. The Attorney General of California, Kamala Harris, is mixed race, but I think father's African American.
The president is black.
The president of the United States. The Attorney General of the United States, Eric Holder, is. Many of the key people in the Department of Justice are. So, interestingly, yes, interestingly, when you look at all the various percentages of people in support, 60%, for example, of people who self-identify themselves as liberal support the death penalty. The lowest percentage of support is non-whites, and that's down to 55%. And probably because historically in America, particularly before the 1980s, I would say, that race was used. I mean, and you want to talk about what happens when you allow juries to disregard the law. All you have to do is remember that's an iconic picture of the Neshoba County Sheriff and his deputy eating popcorn, sitting in the front row, laughing about the murder that they committed, that they got away with in state court. I can't remember, frankly, if they were convicted in federal court. So yes, there is racism in America. The vast majority of murder, and I do speak candidly about it because I think that's important. 51% of the murders in America are committed by African Americans, almost exclusively against other African Americans. In fact, if an African American in this audience, male, is 7 times more likely to be murdered than I am just because of the color of his skin. So in terms of overrepresentation in the system, for women, children, and people of color, it is off the charts compared to that. But to answer your question specifically, I was the chief deputy DA in an even whiter county, and it was a rape murder. The evidence was overwhelming. There was DNA evidence. The guy had a bad record. But I had to look into my heart and soul and wonder whether or not, in a fairly progressive state, Oregon doesn't have any Republicans in any statewide office, whether or not a juror might be inclined, this guy was a transient, he came on the train, that he might vote for a death sentence because he raped and murdered a white woman. And so I guess, in a way, I let race, I have to be honest, factor into that decision that I made.
Not to seek the death.
Not to seek it. And if you look at, statistically, you're twice as likely to be executed if you're white than black. And here's another politically incorrect reason. The kinds of murders, and I think you don't have to be an expert on the death penalty, that get the death penalty are things like serial killings, the killings of children like Marc Klaas, torture murders. To be blunt, it's very hard to find very many black defendants guilty of that. In fact, and my defense lawyer colleagues here will tell you that if you take the robbery aggravator, for example, out of the death penalty, you would knock death row, probably at least 1/2 to 3/4 out as an aggravator.
Barry, let's discuss a little bit about race, and I know you're familiar with some of the statistics here. My understanding, and correct me if I'm wrong, is that African Americans are not more likely to be sentenced to the death penalty, but people who kill white people are much more likely to be sentenced to the death penalty than people who kill black people. Is that right?
David Baldus did a study that was brought to the United States Supreme Court in a case called McCleskey, which was a 5-4 decision, and Justice Powell, when he got off the court, as you well know, said that, gee, I think I made a mistake in that one. Because the race effect that is robust and is consistent is that you're more likely to be executed if you kill a white person than if you kill a person of color, okay? But I'd like to, and that is, I mean, Josh, you candidly say that in your jurisdiction it is not an ethically diverse jurisdiction, but the problem of capital punishment in the United States is a problem in the Death Belt, in California, in jurisdictions where it is dealing with the issue of race all the time. And that is, take Georgia. I mean, the Troy Davis case, I think one of the most disturbing aspects of it.
And just for people who don't know, he was convicted of killing a white police officer And he was executed last week, and there were a lot of issues of witnesses' recantation, eyewitness testimony. I'm sorry, go ahead.
Yes, and let's take it because it goes to this whole issue of, funding the system and the public policy questions that we've been discussing. And you wrote a very good piece.
Thank you very much.
But a very good piece about the Brian Nichols case. And I think Brian Nichols was, this was a case, do you remember when the judge got shot in Georgia?
In Atlanta, yeah.
Atlanta. And
it's just an amazing case. He was in the courtroom and he took guns away and then he went on this rampage. It was incredible, yeah.
Now, the backdrop is that my friend Steve Bright and the Southern Center for Human Rights and a lot of activists in the state of Georgia were working for years to get reform of the indigent defense system in Georgia. And we're talking here about not just representation for capital defendants. They did get reform of a statewide capital office, but we're talking about just representation of people in courts on felonies, on misdemeanors, which was woefully inadequate in the state of Georgia. And finally, in better economic times that we have now, funding was put in place, reasonably good systems were established for, or better systems for indigent defense reform. Same thing happened, by the way, in Louisiana, where we had this whole political movement, brought it to the court, got some indigent defense reform. And then what happened? The Brian Nichols case, one capital case, where, as Mark is pointing out, a great lawyer was brought in because it was a high-profile case and was very disturbing to the community. The resources that were appropriate for a capital trial were put forward. It destroyed indigent defense reform in the state of Georgia. Boom, capital punishment. That's a public policy problem. It's hurting the whole criminal justice system. In Louisiana, after all these years, one case where guilt was not at issue, South Louisiana serial killer in Baton Rouge, where there was DNA evidence, destroyed 15 years of indigent defense reform, and a case some of us had brought up to the Louisiana Supreme Court, the Pert case, that had found the whole system unconstitutional for systemic underrepresentation in funding of defense lawyers. So that is the problem.
Danalynn, I know because I read it in the New Yorker that you were a graduate student before you went to law school and you studied lynchings. That was your field. So you have now been in this field for a long time, in the trenches, dealing with prosecutors, dealing with jurors. How do you see race affecting cases?
I see race as really defining in many ways the death penalty. I mean, I think we have to be real that it's never been the case that the death penalty is our response to murder. It's never been the case that the death penalty is the penalty that most murderers get. It's a tiny percentage of all murders that have ever gotten the death penalty in this country. And then of the people who get the death penalty, only about 30% of them actually get executed. So it is a symbolic thing. And when it's a symbolic thing, what that means is that we're executing somebody to prove a narrative, to say who we are and who we aren't. We're casting stones to say that that is not me. And we're doing that in a very subjective way. The question is always about the death penalty. How do we decide which ones? Because we're only going to do this for a tiny percentage. So it's inherently a subjective question. How do we decide? And all of the Eighth Amendment jurisprudence about the death penalty since reinstatement can really be summed up as arguing over how subjective it's going to be and what's the process of how we're going to funnel down and decide who it is that actually gets the death penalty. And we've ended up with what we call guided discretion. And that means that we've rejected unfettered discretion, which led to racism and that's statistical sort of is provable in a way that is intolerable to everyone. And we're going to also reject mandatory death penalty, which means that we're not going to have any crime where you automatically get the death penalty. It's going to always be this individual sort of guided discretion, and that's incredibly subjective. So what ends up happening, I don't believe that prosecutors sit down and say, I'm going to go choose to execute, to seek the death penalty because somebody's black or because their victim's white. I think most prosecutors are very well-meaning people and that they're making decisions for what they think is going to be the right thing. But I also believe that when you're making those subjective judgments, that the way that we view the value of the victim and the value of the defendant comes into it. And the statistics are very clear that the race of the victim is determinative, and they've done studies where Barry was talking about, where they factor out every other thing. And race is the one thing that can explain how we choose. It's also geographic in the sense that there are really only about a dozen counties in the country where we really have the death penalty. I mean, even in Texas, there's only a handful of counties, about 9 or 10 counties that really execute people. And in Louisiana, the same. I think there's 4 or 5 parishes. So it's something that is very arbitrary and very, very subjective. And when you have people making these sorts of subjective calls based on an emotional sort of response that they're wanting to respond to this horrible crime and do something, then race plays a huge role. And I don't think we can filter it out.
But before we go to questions from the audience, Mark, I'd like to ask you, and perhaps all of you, it seems to me there's a hunger on the part of the system, if you're going to have a death penalty, that you should have a death penalty that's really for the worst of the worst. I mean, the Richard Allen Davises, the Timothy McVeighs. Do you think it's possible for a system, operated by mortals, part of the government, to have a system where you only give the death penalty to the people that, for want of a better term, really deserve it?
I think, first of all, we'll all agree that it's not a perfect system, and that it will never be a perfect system, that there's always fallibility. And Barry's demonstrated this many times, that there are people on death row who don't deserve to be on death row, who didn't commit the crime, and God bless you for getting these people back out onto the streets. But yes, I think absolutely you can go for the worst of the worst people, and we have to remember that district attorneys, the people who are making these decisions, are elected officials. And they're subject to the vote of the people every 4 years. And if the people in their districts feel that they're not doing a good job, that they are in fact racist, as has been suggested, that the court system is somehow flawed and we're putting the wrong people up, then many of these officers of the court should and will be thrown out. But that's not what we're seeing. He's done death penalty cases, and obviously his constituents continue to agree with the charges that he's made because he's been reelected 4 or 5 times now. So sure, there's not a perfect system, but it's a system that is as good as it can. And we've got this appeal system set up so that we can weed out the innocents, so that you can go through the various processes to ensure that the individuals that have been placed on death row are in fact guilty of the crimes, which I would charge is exactly what happened in the Troy Davis case. And I know that we want to talk about the Troy Davis case, and I'd love to open that up a little bit.
Which is, you think he was guilty?
Oh, I do think he was guilty. Here's what I know. I know that recantation evidence had 14 appearances before 6 courts, including 5 trips to the U.S. Supreme Court. And at the hearing in 2010, the very famous hearing in 2010 that was ordered by the Supreme Court, at the end of the day, Troy Davis refused to cooperate with that. That in fact,
the one thing the Troy Davis case is a very complicated case, and I
don't think it's as complicated as people are making it out to be. It was adjudicated in the courts very clearly.
You are certainly right that in 2010 there was a hearing, and the judge wrote a 150-page opinion saying that even with the recantations, he thought he was still guilty. The facts, we just don't have time to go through all of them. But Barry, I'd like to just have you respond to that, in part by an argument that I know you've heard before, which is the Innocence Project shows that the system works because you got these people off death row and they didn't deserve to be on death row, and so that proves that things are better than you think they are.
Well, I talked to some of the people that have spent all this time, 25, 30 years, in prison for crimes they didn't commit, while the person who really committed the crime went out there and committed a whole series of murders. That doesn't sound to me like a system working. That sounds to me like a broken system. And the the problem that we should address if you even want to come close to making the criminal justice system, much less the capital punishment system, fair, is that the resources are put, certainly in California and many other jurisdictions, on the back end, right? The better lawyers get involved ordinarily when you are involved in federal habeas or state habeas.
Which is after the first round of appeals.
Right. And, but when it comes to the actual trial of the case, whether it's an ordinary felony case or even a capital case, very frequently you don't have the resources that you need. And so the system is distorted in that fashion, and frankly, it is undermined our Constitution in the last 20 or 30 years, because there's been a whole series of decisions by the United States Supreme Court that has, we've gutted the writ of habeas corpus. We now have these insane time limits on it. We've undermined other kinds of constitutional rights because these capital cases have been flooding the system, and there have been so many appeals of them that harmless error rules and other rules have come in that have undermined the body of the Constitution. So it's a bit complicated, but the fact of the matter is that capital punishment as a public policy is a failure, because I don't think this, I realize Josh cited some statistics and by Sunstein and others, but I think that a real debate could be had. I think the weight of the evidence is that you certainly can't say we've proven it deters. I don't think that's true. It is very expensive, and if you want to get even close to what you suggested and what Mark is asking for, to have a system that's not perfect but is fair enough, right? It's going to cost a tremendous amount. The state of California shows that they're closing civil courts and destroying my university system. I went to law school there. It's a shame. And there is this unacceptably high risk of executing the innocent, and there are race effects. So you make your decision as a public policy whether capital punishment should continue. I think the case is made that it shouldn't.
Last question, Josh. So can we design a system that works?
Well, I think we can. I think justice is always a work in progress. It's never sufficient to say, okay, it's fine, we've done enough. But I suspect that if you ask Ms. Recer or Mr. Scheck about what specific, fix could be made, and if we could guarantee, Barry and I were talking about double-blind eyewitness IDs, which he's been very involved in.
Tell our friend Joe Hines in the audience.
Joe Hines, who's the Brooklyn DA, is instituted many of these, as a lot of other prosecutors. But if we were to do all those things, my strong suspicion is no matter what we would do, the death penalty would still be unacceptable. And then we fall back to life without parole, which has been offered, as Barry points out, on the ballot in California. There was I believe, another ballot title lurking, which is to abolish life without parole. Because frankly, as a lawyer, I think you can make a hell of a lot better argument that the Eighth Amendment is violated. I have an 18-year-old who I was responsible for getting life without parole. I will believe that life without parole really exists if in 30 years that young man who sexually tortured and murdered a young girl is still doing it. Because in psychology, they say the best predictor of future behavior is past behavior. You can be a parent and know that. You don't need to be a psychologist. That's true of institutions, too. In my state in Oregon, until 1989, when you received a life sentence for murder, you served on average 8 years. So does life without, and then, so I've asked prominent defense attorneys in the past, will you stand up in front of a group like this and say, I agree, life without parole is definitely not a violation of the Eighth Amendment. My suspicion is they will say, no, they can't. When we're talking about funding, my experience is largely in Oregon. I am outspent 20-1 every time I try a capital case, or frankly, even a non-capital murder, which are much more common than capital murders. I mean, and I'm talking about defense experts.
That seems aberrational, I have to say, really.
Well, you know what? The New York Times did an interesting study of that recently, and I used to throw Texas and Alabama regularly under the bus. And the fact of the matter is, I mean, Troy Davis has been having outstanding lawyers. I don't know at the trial level. I certainly know at the appellate level for a long, long time. The idea that, the system is so broken that the only thing that we can do is essentially, well, we're going to take the death penalty off the table. If you believe for a moment that the cost of litigating, and I've done it, life without parole cases is suddenly people are going to say, oh, well, I'm only doing life without parole. I'm not going to file post-conviction relief. And since I have nothing but time for the next 30 years, I'm not going to try to pick apart. And I have retried life without parole cases to the point where the victim's family called me and said, Mr. Marquis, can you promise us this will be the last trial? And I said, no, I can't. And then I had to make a deal for something less than life without parole. There is, one part of what Ms. Recer does is about forgiveness. There's a wonderful parable that I'll steal from Anne Michael, who wrote a book called Fugitive Pieces, which is largely about the Holocaust. And it talks about a rabbi who was traveling, which is probably appropriate given this time of year, is traveling from one village to another. He's very eminent in the Torah, and the more wealthy residents of this town have invited him to come by train. And for reasons known to the rabbi, he chooses to dress as a peasant. And he's treated very badly on the train and disrespected. And when the people who are greeting him, some of whom are on the train and some who are receiving him, realize that they have disrespected this eminent rabbi, they beg his forgiveness. And he says to them, I cannot grant you forgiveness. The only person that can grant you forgiveness is the man on the train, and he no longer exists. Now, Anne Michael was talking about it in the context of the Holocaust. And although we may choose to grant mercy, I believe that forgiveness, which is really at the core of what mitigation is, or at least it was when I did it, and Danalynn, as I understand, has had quite a bit of success at it. That kind of forgiveness, I think, is really only available to probably the divine or maybe people like Marc, but not to me.
Let's go to questions. There are New Yorker colleagues in white shirts. I can't see very well because of the lights, so please ask a question. Come to the microphone. Please don't give a speech, but ask a question. Go ahead, yes.
Yeah, one quick question. This borders on hypothetical. The people who are opposed to capital punishment, are there any cases that you would feel that it would be appropriate? Example, last May, if Osama bin Laden had been captured, brought back to the United States, put on trial, would that be an example of something which you would favor the execution?
Barry, Danalynn? That's a good question.
Whether it's Osama bin Laden or al-Awlaki, who was executed as in the course of an act of war or even treason. I mean, to me, that kind of thing is really beside the point when you're talking about should we have capital punishment as a public policy matter, given what it costs, not just economically, but what it's doing to our criminal justice system in so many ways. And so, again, I'd say reasonable people can differ whether it would be morally appropriate to execute people. And certainly in the time of war, I have no problem with shooting Osama bin Laden between the eyes. I thought that was fine.
Danalynn, if I can ask you to respond in a way, there was an incident that happened in Houston where Grace held a fundraiser. And you wanted to sell T-shirts to raise money. And one of the artists was a client of yours who had been convicted of killing a police officer. And the family of the police officer said, this is outrageous. How can they be fundraising off this killer's artwork? This is a disgrace. Now, and as you pointed out when we talked for the piece, the conventional answer is, well, we don't approve of what our clients do, but we feel they're entitled to a defense. That's not what you said. What did you say, and what would you say about Osama bin Laden?
Well, what I said in that instance was that I'm not going to apologize for loving my clients in all of their complexity, and I don't. I don't do this just because I want the system, because I believe in the Constitution and think my clients are evil, but I'm doing it for the law. What I would say in the before Osama bin Laden, this hypothetical was Hitler or it was some other sort of world figure or despot, and I think that the answer to that is that once someone has been captured, once someone has been contained, once we are able to prevent that person from causing more harm, that it's a different question. It's a different question than in wartime. And I have no expertise in war or the Middle East or what happened there, and so I can't make any comment in that specific instance. But the hypothetical is thrown sort of out there, I think, for the purpose of highlighting whether or not there is any crime that is so awful that we would execute someone regardless of who they are. And I think that we don't look just at the crime, we look at the crime and the defendant, and that's really what our mitigation is about. And I think that what offended people, and the T-shirt sort of instance, we actually had the T-shirts for years and years, but it suddenly became an issue. It wasn't a specific fundraiser, and a lot of our clients contribute artwork, and we have it on our website, in our business cards, with client artwork on a lot of things. And the purpose of that is to let people see that our clients are more than the worst thing that they did. And I think the reason that upsets people is that they want for the clients to be frozen in this one-dimensional image of just the day that they did the most horrible thing that they ever did, and to not know, to willfully say we don't want to be aware of anything else about them because we want to keep them freeze-framed as this monster. And mitigation is saying, no, we're going to see all the minutes that came before and after.
May I, really quickly, the whole idea of selling something that has been created by a convicted murderer is called murderabilia. And quite frankly, by putting this on the Grace website and selling something that has absolutely no value other than the fact that the person that created it had shot a cop in the back at point-blank range 7 times, is a re-victimization not only of the cop but of the cop's family. I can only imagine what that man's widow must have gone through when she found out that you were selling artwork produced by the guy that killed her, that killed her husband. This is and you say that we get these people someplace where they can cause no more harm. Well, excuse me, but I think that Quintero, the person we're talking about, is in a place now where he does continue to cause harm. He's selling T-shirts. She's selling his T-shirts and continuing to cause harm to the family of this man's victim.
I need to sort of clarify that first of all, we've never advertised any of our T-shirts or anything as being created by a particular client.
But it's still murderabilia.
It's actually not. Well, it's not because the client didn't receive anything, but it's also because these are sort of items that when people sign up to become automatic monthly donors, they receive. They also get a calendar. These are sort of giveaway items, but they don't say who they were from. The way that this issue came up, although we'd have the T-shirts for many, many years with artwork from lots of different people, and it's not signed. The way that it came up is that someone began to ask questions earlier this year and hypothesized who might have done some of the artwork on the shirt. It wasn't, not all the artwork on the shirt was from him. But it's never been that we're advertising it as this is done by a particular person.
But you're doing it. You're selling murderabilia. You're raising money for your organization off the so-called talent of somebody who has no other talent than the fact that he could shoot somebody in the back at point-blank range 7 times.
And I think the point is that he has other talents, and that is the point. That is not all there is to know about him. That isn't, and that is the point of mitigation.
Actually, that is all you need to know.
Let's go to the next question.
My question is for
Could
Mark.
you come a little closer to the microphone so we hear you? Closer.
Even closer, like
this?
Yes,
okay. Perfect, yes.
My question is for Mark, and it's a total hypothetical. And when you were talking about your daughter, you said that you, and correct me if I misunderstood you, but I think what you said was that you wanted Richard Allen Davis to receive the death penalty because it was the top it was the top penalty that he could get. And if this crime was not worthy of the top penalty, then it was disrespectful to your daughter's memory. Is that right?
That's, I think, almost exactly what I said.
Perfect. My question for you is, what if you had lived in a state that didn't have the death penalty? Would something other than the death penalty have satisfied you if it was the top penalty offered by that state?
Really? That's the question? Yes.
Okay.
Yes.
That's all.
Okay. Next question.
I would like to point out, as far as
Barry,
that's mandatory life without parole is a which I think, Josh, even most people now, we see in the public opinion polling in California, whereas a few years ago they believed, oh, that'll never happen. Now people really see that that can and will happen. In lieu of, if that is the high punishment, that would be the punishment. There are many people who are sentenced to death that are what they call volunteers. They would rather be executed than have mandatory life without parole. So if what you're interested in is, the harshest possible sentence for the most heinous of crimes, that's a pretty powerful one. And that's one reason, again, that I think is a public policy matter. If you have that as the remedy, you solve a lot of problems in the system.
I could add, we're running out of time, so if people could keep their questions and answers short, please go ahead.
It's a very short question.
A little closer to the microphone.
And it's a question for anyone who, under any circumstances, is in favor of the death penalty. And the question is, would you be willing for one innocent person to be put to death in order to continue having
Josh, what do you think?
I do not believe an innocent person has been executed in the modern era.
I'm not saying that.
Hold on.
I'm saying, would you?
I think you have to, if you're for the death penalty, you have to accept the possibility that it could happen. And so, yes. I would never want to say, yes, it's acceptable to me. But if you have a death penalty and you have human beings being fallible, and it goes on for a long period of time, there is a possibility that an innocent person can be.
And that's the argument against the death penalty.
Next question. Let's keep going.
My question really is more about how, let's say, prosecutors decide who to go for the death penalty with. I've been involved as an expert witness in jury compositional challenges, so I've seen this in a lot of different ways. And my impression is that it's generally done for political reasons, not necessarily for racist reasons, sometimes because the prosecutor wants to run for a higher office. I've seen that in a number of cases. Sometimes when Ashcroft decides he doesn't like...
Josh, what do you think?
Let me explain. I've run for office 5 times. I have never used the fact that I have obtained a death sentence. I'm on the board of directors of the National District Attorneys Association. I am not familiar. If you want to move up to higher office, let me give you a clue. Don't become a DA, because you are going to. It's a lousy way to move up in political office. The only person in the United States that's ever even run for president was Thomas Dewey, who was a prosecutor. And there are a grand total of 6 people in the United States Congress out of 535 who were district attorneys. The decision to answer your question is an incredibly solemn and important one that has to be made highly individually based on the nature of the crime, the nature of the victim, the nature of the background of the defendant. You have to realistically look at the mitigation evidence and really determine in your heart and your soul and your mind, is this person one of the worst of the worst? And as a prosecutor, am I willing to stand in front of a jury and say, this person deserves it?
If I can just add one little point to that, we have in this country, in many parts of the country, not district attorney, judges who run for office bragging about how many people they executed. Justice O'Connor, one of the causes she's devoted her life to since leaving the Supreme Court is trying to end judicial elections. But imagine, I mean, putting aside the whole issue of district attorneys, appearing in front of a judge who's going to run for re-election, bragging for how many people he'd sentenced to death.
Well, and the important point here is that in Alabama, for example,
which is one of the states I'm referring to,
that you can have judicial override. So there are cases where the jury gives life and then the judge who's running for re-election sentenced the person to death. The article to read about this, I hate to be citing all these articles, but it's a long.
Feel free.
Professors Jim Liebman and Jeff Fagan at Columbia Law School wrote a very, very extensive analysis of the death penalty. It's called the Broken System articles, where they actually go and look at different counties, and counties are really the entity to look at, and you can do a measure of political influence. So they were able to identify those counties where this happened. So I'll stipulate, Josh, you're a great guy, and you wouldn't do it, but there are plenty of jurisdictions where politics enters into the death penalty and choosing who should be
Go ahead,
charged.
but lean close to the microphone.
One of the chilling things I read around the Troy Davis case was a letter sent to the head of the Georgia DOC by former corrections directors about the potential impact on staff if they're putting someone to death who may not be guilty. So I'm curious if any of you could comment on where corrections staff come out on some of these issues.
Generally speaking, my impression is many people in the corrections field oppose the death penalty. I think there's a lot of reasons for that. I don't think most of them are not actually involved in the death process. But I think, generally speaking, some of the most outspoken opponents of the death penalty are prison wardens for a variety of reasons.
I did a death penalty story for the New Yorker a few years ago in Arizona, and it related to, and one of the things I learned, it was not in the story, was there is a tradition in American prisons that on the day of an execution, there is near total silence in the prison, that the prisoners, that is a sort of unspoken agreement. It's not, of course, 100% observed, but I just found that fact rather moving and surprising.
Yeah, the now executive director of Death Penalty Focus in California and one of the leaders of this repeal referendum that will be on the ballot, and those of you who care about this issue, give some money to this cause, is Jeannie Woodford, who was the warden at San Quentin, who presided over executions and was head of the California Department of Correction. So I think you're quite right that in my experience, and there are quite a few people who are in the Department of Corrections, and I think a lot of the reasons that they do it is that they do see these people as human beings, and they do know of instances.
By the way, and I know your time.
Yes, I know. We'll just do these last four and then we'll be done.
If California abolishes the death penalty, they will be the first state since 1976, because all of these other, Illinois, New Mexico, New Jersey, none of them have been done by vote. In fact, in Illinois, the proponents of the abolition have been doing everything to prevent a vote of the people.
No,
by the way, Woodford was profiled in the New Yorker by my colleague Ted Franz.
And Josh is exactly right about that, because this would be, it has to be repealed by referendum, because very interestingly, it was put back after reinstatement in California because Jerry Brown, when he was governor, was vetoing it. So yes, I think we're in agreement that if California votes to repeal the death penalty with all 700 people on the row under these circumstances, it is an extraordinary step forward in what I think is going to be within our lifetimes one of the great civil rights movements, and that is to repeal capital punishment in America.
Yes, ma'am.
Yes, hi. I have to sadly say that I
closer to the microphone.
I can empathize with Mark. My father was murdered for burglary and for money. And I don't understand, why are we bothering with DNA testing? In Mark's case, we know that this man killed his daughter. And I don't understand why he can't decide what we should do. We know for a fact that this man's daughter was killed by that person. And if I knew who my father's murderer was, I would like to make that decision myself. I understand there are some families who don't feel that way, but there are some families that, every family on an individual basis, if the DNA tests, if everything is very clear, they should be allowed to make that decision.
Mark, let me just broaden that question a little bit. First, do you think that you and your family had enough of a voice in the case against Davis? And do you think the families of victims in general do?
In our case, absolutely. We had a great district attorney who kept us in the loop and during every phase of that trial. He asked our opinions. We did want the death penalty. This is not a decision I can make. Obviously, this is a decision of the state. We trust in the state to do the right thing for us. But, and I know this is probably my last opportunity to speak here, so I want to say that what I believe is the great irony of this panel is that the people that most want to see an innocent person executed with irrefutable DNA evidence are the abolitionists. And the people that most do not want to see an innocent person executed would be the proponents of the death penalty. And I say that because they, and as Josh pointed out, it's time after time after time they parade out these guilty individuals and claim that they're innocent. They put them on the covers of magazines. They run the stories for years and years and years until it's proven that they're guilty, and then it just disappears.
I think you should be allowed to respond. I mean, is that what you want? To see, you know, the Cameron Todd Willingham case? Doesn't he prove your point? Isn't that what you want?
Well, I think that we could go into detail. I think we've proven that point. But the truth is that when the Virginia matter happened and we finally did get DNA testing there, lots of proponents of the death penalty were infuriated with Governor Warner because he was allowing DNA testing in that case. I've had a number of cases, one in Georgia where Crawford, where we got 4 votes for certiorari, but we could not get a 5th for a mandate at the last minute to try to get DNA testing in that case that could have proved them innocent. We have another case in Tennessee, Sedley Alley, where right now, again, he's already been executed, but we were not allowed to get the DNA testing while he was alive to get a data bank hit. Now the Tennessee Supreme Court has changed its ruling, and we should be entitled to get that. We'd like to get it. Maybe he's guilty. Fine. I'm always in favor of finding the truth and doing DNA testing in any case, come what may. We want the truth. But the real point, Mark, I have to tell you, because it's the death penalty proponents that always oppose the testing at the very end, right? Our side only has to be right once.
But you have
so
to,
they
and
try
that's the
to,
point.
No, because
that's the point. You only have to be right once, and you keep parading these guilty guys out and saying we're right this time, and you haven't been right yet.
As far as I'm concerned, in every one of these cases, and it's non-death penalty cases, any kind of a case, if DNA can shed light, we just want to find out the truth. The problem that we have is all these kinds of procedural bars have been put in place to prevent the testing and getting at the truth. And your statement, which I think is wrong factually, and I can demonstrate to you because I know you're fair-minded about this, is that we were stopped in efforts to get DNA testing for so many people who had already been executed because people that are proponents of the death penalty are afraid that we'll be right that once.
Yes.
Yes, I have a
closer to the microphone.
Can you hear me now?
Yes.
I have a comment and a question. I'm a little bit on the line as to whether it was right of our country to go in and kill Osama bin Laden. We're not at war with Pakistan, number one. And number two is, it would have been nice if we did it about 10 years ago. But things happened.
I don't think it was for lack of trying, to tell you the truth.
Well, but now we're very aware that Al-Qaeda is very spread out all over the world.
But anyway, we don't want to talk about Al-Qaeda in particular.
But the killing of Osama bin Laden has to do with the death penalty here in the sense that, to me, it showed a total disregard for legal procedure. And we didn't bring him in as a war criminal. We didn't give him a trial. We didn't do what we do in our country, which makes our country great. And I think that capital punishment is something that doesn't make our country real great. We did it to him, and everybody's clap, clap, clap. I mean, it's the same.
Do you have a question?
Yeah, the question is, do you think there's any type of a comparison between the two acts? And what was the meaning of the killing of Osama bin Laden in terms of...
You know what? I am going to exercise my unreviewable power as moderator and simply not... I mean, we don't need to get into Osama bin Laden here. I just think that we've had a terrific conversation. We're over time, and I think it's appropriate to thank our... This has been a terrific discussion. Thank you all for coming.